gave you the big paper. I see how it is.
You can see how well prepared I was.
All right, I think we're going to get started here.
This just now, so it looked like I had something.
All right, I think we're going to get started here. Hello, my name is Christian Townsend, and I am the president of IU Mauer's chapter of the Federalist Society. The Federalist Society is a nationwide network of judges, scholars, lawyers, and law students who believe that the idea of carefully circumscribed judicial powers is just as important today as it was for our founders. Through the Mauer chapter and others across the country, we promote and encourage public debate on key constitutional issues. Today, we are excited to welcome Professors Justin Walker and Ian Samuel. They will be discussing the Kavanaugh nomination and the future of the United States Supreme Court. The way we're going to be formatting this today is that each professor will have 10 minutes to discuss their ideas on the Kavanaugh nomination and its impact, and then they will each get 5 minutes to comment on the other discussion. So let me introduce our speakers. Justin Walker was born and raised in Louisville, Kentucky. After graduating from Duke University and Harvard Law School, he practiced appellate law in Washington, D.C., and clerked for Judge Brett Kavanaugh and Justice Anthony Kennedy. He taught as an adjunct professor at the University of Louisville, Brandeis School of Law in 2014, before joining the faculty in 2015. Professor Ian Samuel is an associate professor of law here at Mauer School of Law. Before coming to IU, Professor Samuel was a law clerk for Justice Antonin Scalia on the Supreme Court. He'd like to comment that he believes he's Justice Scalia's only socialist law clerk, a fact that he holds with great pride. And before that, and with Judge Alex Kaczynski of the Ninth Circuit. He has worked at the Justice Department and in the Appellate Litigation Department of Jones Day. A graduate of NYU School of Law, Samuel specializes in cybersecurity and is a co-host of the popular Supreme Court podcast, First Mondays. Let's welcome both of our speakers, and Justin Walker will begin.
Thanks a lot, Christian, and thanks, Ian, for being here today. Ian and I have been on a panel before, so he knows that I'm a First Mondays fanboy. But it's a treat to be on a panel with him because I usually listen to First Mondays at double speed. And so now I get to really soak in what Professor Samuel has to say. I had talked with, not Christian, but maybe Jason before, and maybe we didn't get quite back to Christian. But I think we talked on the phone yesterday about how to make this a constructive conversation and a respectful conversation. And what we thought we would do is each share some initial thoughts about Dr. Blasey's accusation, and then that will probably be all I have to say about that. And then talk about, if Judge Kavanaugh is confirmed, what his jurisprudence would look like and what the merits or opposition to that might be. So there are millions of leaders of the Me Too movement, and a few of them are famous, and some of them have shared their stories only with their closest friends, and others are known only to their assailants and to God. Many of them are heroes of mine, and a few of them, I'm blessed to say, are friends of mine. In addition to the illegality and the immorality and the inhumanity that they have had to endure, they also face a he said, she said framing that I think is often not helpful and not healthy. And so I do not doubt women's accusations easily or quickly or often. And not that you should care about my opinion, but to my fellow conservatives, I don't think you should doubt them easily either. But without reservation and without hesitation, I do believe Brett Kavanaugh. I know him as the person who would rather lose a job than tell a lie. There's a line from the movie Patriot Games where someone challenges Jack Ryan and says, "Name me one thing in this life you are 100% certain of." And without missing a beat, Ryan says, "My mother's love." And I can tell you that's on my list of certainties. And so is the word of Brett Kavanaugh. That's all.
Yeah, so when I was trying to think through this, as we were talking yesterday, and as I've tried to think through this in general, as a person who, I've met Judge Kavanaugh once or twice, but I don't know him, and I don't know Dr. Ford. And I've been thinking about the reality that the truth is we live in one of two possible worlds, and neither of those worlds is very good at all. The first possible world we might live in is that Dr. Ford is telling the truth and accurately remembers exactly what happened. And that's a terrible world to live in because it means she's been living with something horrible for decades, something was only possible for her to talk about really in 2012 in marriage counseling for the first time in any detail. That is a terrible world to live in. The other possible world we might live in is that she is either making a mistake or lying and Brett Kavanaugh is innocent. And that is a terrible world too, because it means that he is going to be put through something that will be excruciatingly painful and damaging. And neither one of those worlds is any good. And I don't have any stable basis in terms of personal relationships or certainly any knowledge to know which of those two worlds it is that I live in. I know, however, it is extraordinarily important to try to do our best to find out what of those worlds we live in. And as I've been thinking about it, I was thinking about it from the perspective of if I live in that first world, and Dr. Ford is telling the truth, what would she want in terms of the procedures ahead of us? And if I were living in the second world and Judge Kavanaugh is telling the truth, what would he want in terms of the procedures ahead of us? And I think about this a lot because I teach civil procedure, and I think a lot about the importance of a process that is not just fair but regarded to be fair. And I think that in the first world, what Dr. Ford would want, and in the second world, what Judge Kavanaugh would want, is more or less exactly the same, right? What they would want is a procedure to either validate their claims or validate their innocence. They would want a procedure that was perceived to be fair by everybody else. In other words, if you are Judge Kavanaugh and you are perfectly innocent and you are telling the truth, I think that what you would want is a process that even your opponents can respect and that is legitimate. Because if there's really no worse fate imaginable than to be telling the truth, but not to be believed because a rotten procedure made it seem like you weren't telling the truth, right? And that's true for both of them. And so in that respect, I don't know, as I've watched this unfold, that Judge Kavanaugh has actually been all that well served by his allies and his friends, not you, but in fact, by contrast to many of the things that were just said, which I think were quite important, because there's three possible responses to an accusation like this. The first is, this is not true. And that is what Judge Kavanaugh has said the entire time, and that is all he has said the entire time. Now, that is a large stakes kind of claim, because all that does is ensure that if you are not believed, that's it. It puts your credibility on the line, and it says, there's no room for gray here. I'm telling you that this did not happen, and let us have a procedure where you can decide for yourself whether you believe me or whether you believe Dr. Ford. That is one possible claim, and I think that that is a respectable sort of claim as long as it is true. The second kind of claim is what I will call a sort of boys will be boys claim. And I have noticed a disturbing frequency with this sort of claim. It is not something that Judge Kavanaugh has said, and even with the little bit I know about him, I can't imagine it's something that he believes. But it goes along the lines of, look, maybe it happened, but don't 17-year-old boys do that kind of thing all the time? Which is the sort of question that really ought to shock the conscience, because I do believe that the speakers who are saying it really think that way. And that is a serious problem, because, look, I don't have a 17-year-old son, but if I did, I would not want him to be hearing, go ahead and, attempt to rape someone. We all know that that's what 17-year-old boys do. And I don't think that Judge Kavanaugh thinks that way, and I don't think that's the kind of values he's imparting to his children. And so I really wish he would, one of the things I would want to say if I were him at this, public hearing that it seems likely that they'll have is, if you are my ally, spare me your clumsy help if that's what it's going to look like, because what I'm telling you is I didn't do it, and I don't need you to be making excuses for me if it turns out that people think that I did. If people think that I did it, then they've made their judgment, and I do not want to then have a further argument about how bad it really was. So in that sense, I don't think he's been that well served by his allies, but I also don't think he's been well served in the sense of the begrudging nature by which it has felt that the Judiciary Committee has wanted to evaluate these very serious allegations, right? Because, for example, saying we have to hold the vote as scheduled on Thursday no matter what, and sort of blaming the sort of minority leadership on the committee for not bringing this up sooner, it gives the sense that there is something to hide. And if you are an innocent person, if you are Judge Kavanaugh and you are saying, and let us assume you are saying truthfully, I don't have anything to hide, and I would appreciate it, you might then imagine him saying, if you would stop making me look like I did, right? I am comfortable testifying in public. And indeed, I can imagine if I were accused of something this serious, and this is an incredibly serious accusation, I would demand to appear in public and say myself, not in a statement through the White House or anybody else, I would demand to appear in public and say so in public with every camera on God's green earth pointed at me so people could observe my demeanor and decide for themselves whether I was telling the truth. And so the sense that maybe we'll do this by phone calls, or maybe we'll do it in a sort of closed session, or maybe we won't do it at all. I don't actually think that well serves Judge Kavanaugh if we live in World 2. In other words, if we live in the world in which he is telling the truth. And so I think that a lot of that has been a sort of product of panic and sort of emotion clouding reason. And what I have been glad to see is that over at least maybe the last 24 hours or so, there's been a kind of receding of that there has been a sort of admission and a sort of welcoming of we're going to discuss this in public in a procedure that I hope it will be regarded as fair. Because when this is done, one way or another, Judge Kavanaugh will either be confirmed or he will be not confirmed. And we will all have to live with the consequences of the procedures we select to do this. And as we look back, many of you probably weren't even born during the Anita Hill episode when Justice Thomas was nominated to the Supreme Court. I don't think anybody looks back on that with much regard for the process that was used there. And I don't think that the allies of Justice Thomas, who believe his innocence, look back on that procedures with a lot of affection, and I certainly don't think that Anita Hill and her allies look back on that process with any affection either. But now we are at the start, and we're going to have to choose what this is going to look like, because if it's not satisfying to the people who lose, it is not a procedure worth having. And so I hope that as this unfolds, that is kept in mind, that whomever is telling the truth here, it really would be in their interests if the people on the other side are satisfied that the procedures were fair, because the truth is we are not going to be able to see this as God sees it, and we're going to disagree about this for a long time after it happens. And I just hope the procedures that we can settle on are worthy of a decision of this importance. So that's what I kind of have to say about that.
Well, I don't know a transition to what Judge Kavanaugh's jurisprudence would look like if he's confirmed.
It's just paradigm shift with no clutch on that one.
But I think that I hope that he will be confirmed, and I think that it is worth discussing whether, on the merits of his jurisprudence, that will be good for the country or not good for the country. And I'm quite in the camp of the first category. One of the things that I think we would see is an approach to separation of powers that combines a lot of other strains and lines and narratives that are not wholly original, but that, if you look at Judge Kavanaugh's jurisprudence over the past 12 years, kind of come together in what I would suggest is a pretty coherent way, even to the point where I can imagine what a Kavanaugh Constitution would look like when it comes to separation of powers. Judge Kavanaugh used to always tell us as clerks that every case is a separation of powers case, regardless of what claim is actually raised. And that's because every case requires the judge to remember the limited role of the judiciary in our three branches of government, where it's the legislative branch and the executive branch that are supposed to make policy, and it's the judiciary that's supposed to apply the law in a neutral way. And I've listened to enough First Mondays to know that Ian is skeptical that judges can do that, even well-meaning judges who take that as their goal and their mission. Having worked with Judge Kavanaugh, I saw him strive to do that. And I think reasonable people can disagree over how well he has accomplished that mandate or how well any judge has accomplished that mandate. But I think that among the elements of that approach that he brings to the question of separation of powers, the question of who decides. He used to talk often, and you see this in some of his opinions. The question is not what should the decision be on matters of policy. The question is who should decide that policy. And, he's given several speeches in addition to the 300 opinion. He's written speeches and academic articles in some of the best journals in the country. And I think what comes across that I wanted to focus on are two elements of that. One is his approach to text, and one is his approach to agency questions. So actually, I take the agency questions first. Judge Kavanaugh had a case where Congress had allowed the agency to create promulgate an environmental regulation if it was appropriate. That was the key word. And, however much we might disagree, I think we can all agree that the word appropriate is a fairly broad word, a fairly imprecise word. But I also believe that Judge Kavanaugh was correct in this opinion to say it is not a word that has no limits whatsoever. And so when we analyze whether or not an agency's regulation, in this case it was a $9 billion per year regulatory burden on the economy, whether we believe that's appropriate or not requires us to at least consider the costs and the benefits of the regulation, and not just the benefits. And so in this case, which was this your term? Did Justice Scalia write this your term?
Which one?
This was the EPA S54. I'm trying to remember.
Oh, no, that was 2 years after.
Okay, so I think it was a mercury regulation. So Justice Scalia wrote a 5-4 opinion in which he said that the EPA cannot promulgate this regulation if it only considers the benefits of the regulation and doesn't consider the costs of the regulation. And that was Judge Kavanaugh's position as well. But Judge Kavanaugh was in dissent on his panel on the D.C. Circuit. So the question there, again, was not, is this a good policy or is this a bad policy? The question is, when Congress allows the EPA to create this policy, did Congress allow them to create it with when they consider only the benefits, or do they have to consider the costs as well? And it goes to a larger question of how just what can agencies do absent clear language from Congress? And, as you know, agencies are run by administrators, whether they're an independent agency or whether or not they're an agency that's headed by someone removable at will by the president. They are headed by someone who is not elected by you. And so if you look at the first line of the first article of the Constitution, it says that all legislative power herein granted shall be vested in a Congress, which suggests that at least the most important laws in our country should be decided by the people that we elect. That is not the world that we live in. If you were to make a stack, and I've seen Senator Lee has a stack in his office of all the regulations that were passed by agencies, promulgated by agencies in the past year, and he has another stack of much smaller stack of the statutes that were passed by Congress. The list of regulations promulgated by agencies, which have a $2 trillion regulatory impact, a hidden tax on the American people, is exponentially larger than the laws that were actually passed by the people that we voted for. Now, I don't think that I am not saying we can or should or need to go to a regulatory structure where agencies do not pass regulations. But I do think that there's at least reason for pause, that so much of the rules we live on were not passed by anybody we elect. And there's problems with that for lots of reasons. And one of the problems with that is that it allows our members of Congress to get away with a little trick, where they pass a law with a nice title, and the law promises lots of benefits, and then they can run for re-election and say, look, we passed a law with all these benefits. But the law doesn't say who has to pay the cost of those benefits. And so it's the agency that determines whether you pay the cost, or you pay the cost, or this business or that business, or this industry or that industry. And then if the agency chooses poorly, the people who are forced to pay that cost aren't able to say to their representatives, well, this is your fault, because the representatives can just say, oh, well, we didn't make that decision. It was the agency that made that decision. Now, if you imagine a spectrum of how we might approach these agency questions, on one end of the spectrum, I think, is where we have been for several decades, and this is the Chevron Doctrine, where judges first asked if statutory language is ambiguous, and then if it is, they defer to a reasonable interpretation by the agency. You could imagine a different regime, the next step along the spectrum, where we don't defer to agencies. Judges just read the statute and try to figure out the best answer. And then if the agency regulation is authorized, then the agency regulation is authorized. You can imagine a next step, which the Supreme Court has hinted at times, where at least on major questions of policy, we would read into the statute a presumption that Congress did not intend to allow the agency to do what has not been expressly authorized. And so it would look something like a clear statement rule requiring a clear statement before the agency can act on major questions. And then you could imagine the far end of the extreme, which would reconsider some of our non-delegation doctrine. And there's a case the Supreme Court will consider this year about the limits of that non-delegation doctrine. Just how much legislative authority can Congress delegate to an agency consistent with the first article's first sentence of the Constitution, that all legislative powers here and granted are vested in a Congress. And Judge Kavanaugh wrote an article, it was actually a book review of Judge Katzmann's book, and he suggested that part of the problem with that place we are now under Chevron is that it requires an initial question that is difficult to answer, maybe impossible to answer. And that question is, when is statutory language ambiguous? And he said after serving 12 years on the DC Circuit and seeing agency case after agency case, he has seen that the best intentioned of judges have no way to agree on what statutory language is ambiguous and what is not. Judge Kavanaugh said for him, if it's about 60% clear what the text of the statute means, he would consider it not ambiguous. And so then if an agency regulation is inconsistent with that reading of the statute, he would strike it down. But he said there are other judges who would say statutory language has to be 85 or 90% clear before that judge will say it's not ambiguous. And so then in that, imagine a Venn diagram, those cases that fall in between the 60% and the 90% level of statutory clarity, Judge Kavanaugh is saying, well, it's clear enough, I'm going to read the statute. The other judge is saying, well, it's too ambiguous, I'm just going to defer to the agency. And so you have these massive legal questions that affect, just to give one example, how much money you pay for your electric bill, but any host of other questions that affect all of us. And they're not being decided on what the best reading of the statute is, or even what the best policy is from the voter's perspective. They're being decided on this threshold question of what's ambiguous and what's not. And this has repercussions in other areas, other doctrines that begin with this inquiry into what is ambiguous and what is not. Was the Affordable Care Act constitutional or not? Hard to imagine a more significant legal question. I mean, this was a reform of a seventh or an eighth of our economy. And yet, the case hinged not on whether a majority of the court thought the Commerce Clause authorized the individual mandate, a majority of the court did, and not on whether a majority of the court thought that the individual mandate was best read as a tax, The conservatives and Chief Justice Roberts agreed that the individual mandate was not best read as a tax. Where they disagreed was whether or not the individual mandate's language was sufficiently ambiguous that it could trigger a constitutional avoidance canon that then requires courts to read the text not according to its best reading, but according to a manner that would make it not constitutional. It was that initial threshold question that the fate of the Affordable Care Act hinged on, and it's that initial threshold question that it's very difficult to know what is ambiguous and what's not. So actually, I'm out of time. I don't want to. The textualism point that Judge Kavanaugh has been made many times before. He's spoken about it with passion. And when I was clerking for him, I saw him apply this in a case that the Supreme Court several years later vindicated. Judge Kavanaugh created a 1-4 circuit split. In an opinion he wrote, ruling for a criminal defendant, going to the question. This kind of goes to the question of, well, do judges ever do what do judges ever rule for the guy that they don't think is the most sympathetic? This was a very unsympathetic criminal defendant who had stolen from his employer. It was a federal agency, and Judge Kavanaugh looked at his argument. No court in the country had agreed with it. No appellate court. 4 courts had expressly disagreed with it. Judge Kavanaugh said, "I think you have the best reading of the statute, so I'm going to rule for you." And then in last year's case, Lagos, the Supreme Court vindicated Judge Kavanaugh's textualism opinion, a unanimous opinion written by Justice Breyer. So I'll turn it over to Ian to talk about the separation of powers question, this question of who decides and what the role of the judges is, or to talk about any aspect of Judge Kavanaugh's jurisprudence that you want, Ian.
All right, good. So we just actually wear a watch. I don't want to go over my time. So I think that the question of who decides actually is a useful organizing frame for kind of 3 areas you might think about, and that I think about Judge Kavanaugh's jurisprudence, because I think it's important to distinguish some different things that might be, and different ways we might answer the who decides question. So the first is the area which receives, great public attention, and so I suppose I should say something about it, of unenumerated rights in the Constitution. And you can think of that as a who decides question because it is an answer to the question, for example, who decides if we shall have, abortion in the United States? Will it be judges or will it be the legislature? Who decides whether we will have, access to contraception for married couples? Will it be the legislature of Connecticut or will it be the court? Same-sex marriage, all these sorts of things. And what Judge Kavanaugh said in his confirmation hearing, I think, was the sort of orthodox answer for legal conservatives, which is not that there are no unenumerated rights. The Supreme Court has accepted that there are instances where it really would be unconstitutional to do something to someone to take away their rights, even though there was not an express textual commitment on that point. And the sort of the kind of orthodox answer for legal conservatives of when that is true is supplied by this case called Glucksberg. What Glucksberg says is if a sort of certain right is so deeply rooted in our history and tradition that basically you would not have actually expected anyone to write it down because it would have been beyond their contemplation that anyone would ever try to deny it, then that is a sort of right we can protect. And you could think about examples of this, right? So for example, imagine there were a statute passed tomorrow that required all babies to be taken from their parents at birth and raised in state education centers. You might cast around for some grab bag constitutional provision on that, but what you'd really be reacting to is this sort of like unthinkable infringement on family privacy and of parents' rights and things like that. And I don't think you would get a single vote in the Supreme Court probably sustaining that law. That doesn't tend to do a lot of work in practice because these sorts of like unthinkable horrors generally are not enacted by legislatures either. But that is the sort of, that is the orthodox answer of when that exists. And as Judge Kavanaugh has observed, and he sort of subscribed himself to that in his confirmation hearings, and he discussed Glucksberg and said that Glucksberg is the law. It's fair enough. Now, it doesn't take much imagination to understand that when that doctrine is applied to the unenumerated rights cases that are the most famous ones, so, Planned Parenthood v. Casey or Obergefell respecting same-sex marriage, or a lot of the so-called, right to privacy decisions, that those really cannot be sustained under the rule of Glucksberg. And indeed, in a speech a few years ago, Judge Kavanaugh remarked to the effect of, even a sorry, he said it this way, I think even a first-year law student could figure out that the Glucksberg test could not sustain, for example, Obergefell. And I think that, in other words, and by the way, I think that is true, right? It would be very, very difficult to maintain at any level of generality that the right of two people of the same sex to have their marriage recognized by the state is deeply rooted in this nation's history and tradition. And indeed, Obergefell said that, like, expressly disclaimed that they were trying to apply Glucksberg in that respect. And so that is, in one sense, an answer to a certain sort of who decides questions, right? Like, in other words, a Glucksberg view of the world in terms of unenumerated rights doesn't mean that abortion shall be, illegal nationwide, and it doesn't mean that same-sex marriage shall be illegal nationwide, but it does mean that the answers to those questions would be supplied by legislatures, either the state or the federal government. And stated, if that were all you sort of knew, it would be compatible with two sorts of positions. The first, which I think was kind of what was being gestured at with the discussion of administrative law, is these sorts of important questions in general should be decided by legislatures. That it would be a sort of Felix Frankfurter judicial minimalism, a small role for the courts in deciding major questions of public life. And so, if you people want this stuff, go out and organize and pass legislation and do it. And that was quite fashionable in the early part of the 20th century with FDR's nominees. So Felix Frankfurter was an example, and people like that. But that's not really what Judge Kavanaugh, that's not really what he embraces. And I think one way you can see that is his decisions in a different branch of constitutional law, which is the First Amendment, right? And so Judge Kavanaugh, when he was on the DC Circuit, there was a case about the net neutrality, right? The rule that internet service providers have to treat equally sort of sources of traffic, whether it's Netflix or some little video startup or whatever. They can't discriminate among sources of traffic. They can't throttle websites they don't like, things like that. And net neutrality is obviously a very controversial question. We debated it for many years. The Obama administration passed a regulation requiring it, regulating it under the Communications Act. The Trump administration reversed that rule with the new FCC chair. And so this is certainly a major question of public life. And you might think that if all you knew about Judge Kavanaugh were sort of what Justin described as the major rules doctrine and what I've just said about unenumerated rights, you might think that this would be one of those important questions of public life that would be decided by the agency or a legislature. But that is not, in fact, what he said. And he did not say this matter is too important to be decided by an administrative agency either. You could imagine that would be sort of compatible with a kind of who decides question. Well, it'll be the democratically accountable legislature, not the administrative agency. Judge Kavanaugh actually went quite a bit further than that. And he said, I will tell you who decides whether we will have net neutrality in the United States. It'll be courts, and we can't. Because it is a First Amendment problem. Because the First Amendment guarantees you the right to freedom of speech. Comcast is entitled to that just as all other sort of people and corporate entities are. They are a media company. And if they want to discriminate against this, among this sort of traffic, that is their First Amendment right to do so. And to forbid them from doing it would be an infringement of their First Amendment rights. Now, I am not by trade a First Amendment scholar, and so I will reserve comment on any thoughts about the deep merits of that position, although I will say I am at least skeptical as an initial matter. But do note that it supplies a very different answer to who decides and in terms of the separation of powers than is supplied in the sort of other areas. And this is tremendously significant because as we've seen this last term, and really this has been happening for the last few years, but I think it's sort of flown under the radar until it really got jumped into the public eye this last year. The First Amendment is becoming an incredibly important source of basically deregulatory cases, an incredibly important constraint in the minds of the conservatives on the Supreme Court than that we have previously really had understood, right? That there are all sorts of things that are now off the table that we didn't understand to be off the table because of the First Amendment in a way that legislatures cannot react to. So this most recent term, for example, the Supreme Court decided this Janus case, which they had been driving at for about 6 years, and said, the question of whether public sector unions will collect so-called agency fees from all of the people they represent, even if they're not members, that's an incredibly important question in public life. There were like 20-something states that said, yes, you can do that. There were like 20-something states that said, no, you can't. And it's a really important question of public sector labor law. And the answer to, well, who shall decide whether that is true is, we will, and you can't. Because the First Amendment, basically, there's a free speech problem with making people pay into unions, even if those unions just use that money for collective bargaining, because collective bargaining with a public sector union in the government is always a topic of political importance, and so it would be basically unlawfully compelled speech to have this. Again, I'm not a deep First Amendment scholar, although I think that anybody interested in the business of constitutional law is going to have to kind of become one in the coming years, because this is proving to be a very flexible source of doctrine. But just note that that important public question is going to be decided then by the court, and there's nothing anyone else can really do about it. And you could replicate that over and over and over. For example, whether or not there should be exemptions from generally applicable laws for people who have religious objections to those laws is a question of great public importance, right? And the answer that we have right now is sometimes and sometimes not, right? So sometimes, for example, if you are a Quaker, we will not force you to bear arms in the military, but sometimes even if you have a religious objection, for example, or to a law restricting the use of peyote, right, and you would like to use it for religious reasons, we say in that instance we won't. And these have basically been adjusted legislatively, and we make decisions about how we're going to do that, and it's a question of great public importance. Now, I do not know really anything about whether Judge Kavanaugh believes that the First Amendment requires actually that the answer be yes, we will decide whether those exemptions exist, and they will. Current doctrine is that they won't. I have a feeling that there will be interest in revisiting that doctrine in the coming years, but so I have literally no idea what he thinks about it. But just note that that too supplies a different question to the different answer to the question of who will decide this important question, right? And you could replicate this kind of First Amendment analysis over and over and over and over, because as it turns out, just about everything involves some speech, right? So securities regulation is a regulation of people's speech. Now, it regulates it so that they may not be punished for saying, false and misleading things. But actually, if you study First Amendment doctrine, and even I know this much, as a general matter, you can't prohibit the saying of something just because it's false. Now, you might be able to prohibit it if it's false and it causes harms. But note that now we've got a First Amendment constraint on the securities laws as well. And you could do this in really a ton of areas, and it's an incredibly important and flexible weapon because, back in the early part of the 20th century, what those, FDR appointees were reacting to was the Lochner era, where the court had said, that due process clauses, substantive component basically requires liberty of contract, and we're going to strike down maximum hour laws and things like that. And the hardest problem with that argument has always been that it is quite atextual and doesn't really fit naturally with the words of the Constitution at all. This is a big improvement because it's actually pretty easy to tell a story about how the freedom of speech and the freedom of religion might require some judicial intervention into these areas. And so it's textually plausible in a way that it wasn't before. And the only question is, well, how far are you going to take that? Because when I was in law school, there was a friend of mine who was in the law review with me who wrote his student note basically arguing that, more or less everything, all regulation, because, look, conduct can also be speech, right? I mean, we've seen burning a flag, that's speech too. And if you really have a big picture of what speech looks like, then all of a sudden you've got judicial supervision of just about every kind of regulatory activity that there is to ensure that it does not go too far, which is a very different answer to the who decides question than you might have in some of these other contexts. So the last thing I'll sort of note, because I do want to comment a little bit on this, is the sort of Chevron administrative law major rules doctrine, because this is one of those areas where it's a little esoteric but actually quite important. So I'm glad you brought it up first and sort of did all the explaining of it, so I can just kind of footnote my views on it just a little bit, because I was dreading having to do that, but you did it very well. So the most important thing I think to think about when it comes to that doctrine is that it is asymmetrical in an important sense, which is if an agency passes a rule creating a set of regulations on businesses or whatever, the major rules doctrine, if it is if it's a really big rule, you would start with the presumption that if Congress didn't clearly authorize it, then you can't do that. But agency rules can regulate and they can deregulate. So if you wanted to pass a rule, for example, and let's set aside the First Amendment problems with the net neutrality doctrine, if you wanted to pass a rule saying there shall not be net neutrality, I don't know if Kavanaugh has ever grappled with this specifically, and I'd be curious to hear from you if he has, but my understanding of the conceptual framework of the major rules doctrine is there's no major rules objection to a big deregulatory rule because there's, unless the statute, in other words, it wouldn't make sense to say you must regulate unless the statute clearly said you didn't have to, right? The whole logic of the argument is unless Congress said you can do something clearly in this big area, then you can't. But I don't actually understand that to be symmetrical. And that is extremely important, right? Because what that means is that if you have a government in place that wants deregulation, it can get that agenda through relatively quickly. And it can get that done with a set of deregulatory rules that will not be subject to major rule review. But if you've got an administration and a government in place that wants to regulate more sectors of the economy, that wants to propose to do all sorts of things, then that regulatory agenda is actually significantly slowed down because it goes through this major rules review. And maybe these rules don't get through at all. Maybe you have to go back to Congress and have them amend the legislation, and it's very harder. And that sort of asymmetry, I think, is very conceptually important, right? Because the question of how much regulation of the economy there shall be is a persistent one in American life for very good reasons. It's an incredibly important question. There's literally trillions of dollars at stake. And so the major rules doctrine is also another answer to the who decides question, which is if the agency wants to deregulate, my understanding of the major rules doctrine is then the agency may decide to do that. But if the agency wants to regulate, then it is Congress that must decide that with the attendant more difficult procedures that attend legislation versus rulemaking. And so that's an important difference, and one could be in favor of that difference. One could say, well, I favor deregulation, and so I'm very excited about this major rules doctrine. And that's fine, but just understand the asymmetry sort of in the doctrine in the same way that Chevron has its own, in other words, these things have an ideological valence. They necessarily do. And the only question really before you is, well, do you like that valence or do you not like it as a matter of evaluating what the future is going to sort of look like? So I think that's about 10 minutes and maybe even a little bit more than that. So I'll turn it over to you for a crushing rebuttal.
Great.
If it's okay with both of you, could we switch into questions now?
Yeah, sure.
We've got about 15 minutes left to take some questions. Or do you have some quick remarks?
Let me do like 3 minutes.
Yes, that'd be great.
So, especially on the First Amendment question, because I think I was less articulate than I would like to have been on the question of who decides. It's not that I think Judge Kavanaugh thinks Congress should always decide everything. I think that the choices of who decides should be found in the Constitution. And so on the question of whether or not you have the right to speak about a political matter, or whether or not your union can force you to say political stuff that you don't agree with, I think that what the majority in Janus said is that that's not a question for courts to decide, and it's not a question for state legislatures to decide. It's a question that the American people decided when they ratified the First Amendment. And so, I think people of good faith can disagree about whether that is a correct interpretation of the First Amendment, but they're not really disagreeing about who should decide. The same thing with net neutrality. There's a line in Judge Kavanaugh's opinion where he quotes Ben Franklin talking about a newspaper, and Ben Franklin says, a newspaper is not like a stagecoach. It doesn't have a ticket for everybody. If you run a newspaper, you get to decide what you publish. And I think people of good faith can disagree about whether or not an internet service provider is analogous to a newspaper in terms of them deciding what speech they are going to agree to communicate and what speech they might decide not to communicate. But I don't think it's a question about whether or not a question of who is deciding or not. So I think the last thought I would have on that, and it'd be fun to talk more, but I want to stay true as close as I can to the 3-minute rule, is that another line of Judge Kavanaugh's cases concerned whether or not the CFPB and which is the Consumer Financial Protection Bureau, and also the Public Accounting Board that was created in the wake of the Enron scandal by Sarbanes-Oxley, were constitutionally structured or not. And he didn't say, well, Congress can't decide whether to regulate consumer protection, and Congress can't decide whether to regulate accounting boards. What he suggested is that when the Constitution was ratified, the people who ratified it had made a choice about whether or not there could be an agency of the federal government that was not accountable to the president and therefore not accountable to the people who elect the president. And in the case of those two agencies, Congress had gone out of its way to create agencies that were as independent as possible from the president and thus as independent as possible from the people. And in Judge Kavanaugh's opinion, they had gone a step farther than the independence that had been created by the independent agencies during the New Deal and that had been authorized by Humphrey's executor. So even in those cases, I see a commonality, a consistency with the theme of Judge Kavanaugh saying, okay, it's not a question of what regulation is good or what regulation is bad. It's a question of who has the power. And in the case of those agencies, the people who ratified the Constitution made the decision that the president, accountable to the people every 4 years, should have that power. So you deserve 3 minutes.
I will take 15 seconds because I really do want to give people time for questions. And I will say that I think this is why I like doing panels with you, because it's like playing chess with your friend and you both know the openers, like you know all the moves, because that's exactly the right response and you know exactly what I'm going to say, which is you said, and I think it's true, that good people can disagree about whether the First Amendment, for example, permits agency fees, right? But that just pushes the question one level back, which is who decides the answer to that question, right? So like if good people can disagree about it, who's going to decide it? And the answer judges will and the answer legislatures will are two different kinds of answers. And so we just really replicate the same disagreement at that level. But that's probably even more than 15 seconds, but now I'll yield. And you could have 2 seconds of surreply if you want.
So we have people running mics on either side. If you would say who you're directing the question to, that'd be great. And please wait for the microphone.
We answered it all.
Yeah.
It's a lot easier than the Kavanaugh confirmation here.
This question is directed to either whoever would like to take it. Could you speak a little bit about how you anticipate Judge Kavanaugh could come out if and when the court is ever asked to interpret or apply the undue burden standard as articulated in Whole Woman's Health? There is only one, to my knowledge, only one time that Judge Kavanaugh really grappled with it and didn't really seem to forecast much of how this could come up. And of course, it didn't come up really in a meaningful way in the hearing. So I'm wondering if you could sort of elaborate on how you think that might come out.
You want to go first? Or me go first?
You're the guest. You go first.
So Judge Kavanaugh has written a 1,000-page book along with 12 other distinguished judges called The Law of Judicial Precedent. And I take him at his word for what he says in that book. And that is that, of course, under extraordinary circumstances, precedents should be overturned. But as a general matter, fidelity to precedents, including Roe and Casey, which are mentioned in that book, Judge Kavanaugh says that as a general matter, fidelity to precedents encourages stability, it promotes predictability, and it's important to the rule of law. I don't think that I agree with you, I don't think we learn a lot about his reading of the undue burden standard from the one and only abortion case that he decided. But as far as predictions beyond that, I think I've made enough bad predictions about the Supreme Court in the past that I've quit setting myself up for failure.
Yeah, I mean, my view is that the problem with Casey's undue burden standard has precisely been that it is so malleable in its application. It literally calls for an evaluation of whether, in the opinion of a court, a given restriction on abortion is undue, which is to say goes too far, but doesn't really supply a lot of meaningful content of that, or at least what content it attempts to supply is sort of equally unclear. So Roe gave us a pretty clear trimester system, right? Which is like, here's the rules for trimester 1, 2, 3. And it's not that actually hard to figure out, but it's quite rigid, right? So Roe is like a rule. Casey is like an open-ended standard, and the problem with it has always been that different people on the court are going to disagree about when an abortion restriction goes too far because that's not really a legal question in any meaningful sense. You could imagine a regime of abortion rights that did not have that characteristic, but that is the one we have. And so based on his opinion in Hargan v. Garza, which is I think the case that you were referring to, where he was, I think, comfortable reading the sort of parental rights cases quite expansively in that case, although I don't think I wouldn't say he was stretching them beyond their breaking point, but I think that I would regard them as a significant extension. I wouldn't, in other words, if you just told me, look, you have here in front of you a brilliant legal conservative who has sort of spent his life in public service on the DC circuit in various very important, very high-octane government jobs. Do you think that he thinks Roe and Casey were right the day they were decided? I'd be like, of course not. Of course he doesn't think that. In the same way that I would supply the same answer for a sort of brilliant liberal. Of course that they think that at least the reasoning of the result in this case is right. I don't think there's any reason to doubt that. The further question of whether they'll be overruled is of course a hard one, but at some level I think we're going to find out pretty fast because there are a lot of very innovative abortion restrictions that are percolating through the federal courts. So for example, there's these discussions of like the so-called heartbeat bills, which bans abortion after a fetal heartbeat is detected, which is about 6 weeks into the pregnancy usually, which can can be about 2 weeks after the woman finds out that she is pregnant, because you count from the previous missed period, from the previous period. So those bills will reach the court, and we're going to get an answer to that sort of real soon. And so I think it's perfectly easy for me to imagine Kavanaugh, a brilliant guy, writing an opinion that says giving someone 6 weeks to decide this important question is not an undue burden. You just can't sleep on your rights, right? And there was actually a sort of, I saw from somebody, it might have been, I don't remember who it was, actually kind of wrote a little draft opinion saying, look, it's actually not that hard to write that opinion because undue burden is quite malleable. So I don't know either, but we will see it very soon.
This is also directed at both of you, but perhaps a little bit more Professor Walker because of your familiarity with him personally. But I'm wondering in a broad sense about Judge Kavanaugh's approach to recusal in various circumstances, because I think given the field from which we pull our Supreme Court nominees now, a lot of them come from the D.C. Circuit, have done in the recent past, that there are many cases in which recusal is appropriate for judges who have either seen a case before or have expressed an opinion in a similar case before, and not so much the high-profile ideas of when he should recuse himself, but in a broader sense, what is his approach to recusal, or to seeing how he may have expressed himself? He was so cautious in his hearings, as many of them are, to not express opinions. What is his general thought process when it comes to that question?
I don't think I have any inside information on this because I don't remember a case that raised that question when I was clerking, but I would guess that he would follow the tradition and the norms that all the other justices on the Supreme Court follow, which is that if it's a case that he had any involvement in before, then I think most of the justices, if not all the justices, would say that's grounds for recusal. If it's a case that a justice had no involvement in before, but that raises a legal question similar to a question they've decided before, the tradition for judges is to decide that case and not recuse. So I'd be surprised if he doesn't follow any of the. I suspect he'll follow all the norms and traditions.
Let's have one more. Time for one more?
One more question, yep.
I said let's have one more.
So this is more for Walker, actually. So the evidence shows that judges specifically prefer their ideological beliefs in matters that don't have a clear answer, or rather can be adequately supported by multiple different types of reasoning. So do you believe it's important for the Senate and the public to know what Judge Kavanaugh's personal beliefs are in a lot of these really contentious issues?
So I think that I would disagree with the premise a little bit. And we touched on this a little bit before. I know that Ian and I disagree about this to a degree. We might not disagree as much as anyway about all judges. I think that it's really important for a nominee to be open about their approach to the law. And in the case of Judge Kavanaugh, I actually don't think that there are a lot of mysteries about his judicial philosophy. 12 years on the second most important court in the country, 300 opinions written by him, articles in Georgetown Law Review, Minnesota Law Review, Harvard Law Review. Hasn't, I was just, as an aside, it's a dream of mine to be published in the Indiana Law Journal one day, but I'm working on that. I think that even before the hearings began, that we didn't have to guess what kind of judge he would be, in the way that other extremely qualified nominees who are brilliant attorneys, Justice Kagan comes to mind. I think John Roberts was extremely qualified. Justice Kagan had not been a judge. John Roberts had only barely been a judge. And so I think in their instances, maybe there was more reason to not be sure of the kind of approach they would take to the law. But I really think that although it's unethical for a judge to promise how he will come out on a particular case, and you saw Judge Kavanaugh say that, 100 times, and you saw the other 8 nominees to the Supreme Court who are on the court now say that 100 times, at least on questions that they had not written about before. Although they can't make predictions about specific cases, that wouldn't be ethical. I do think that, it's good for them to talk about their approach to law. I think it can be an educational experience for the viewer.
Yeah, and I know you didn't really direct this to me, but I have a microphone anyway. So what I will say just further to that is I think it would actually be quite healthy if the norm were a judge is expected to and should answer any question that would be respectable to put in a concurrence, because if you have put it in a concurrence, then we can talk about it. And I think the fortuity of the fact that it's never come before a court, I don't know why it should matter so much. Now, the answer might be, honestly, I don't know, right? Because not that I have some secret view that I'm keeping from you, because it would be improper for me to comment on what I think the right test for substantive due process is. But I'm telling you, I don't know, right? Because there are lots of things that I have strong views about, and lots that I don't. Like what's the right, rule to apply in the Seventh Amendment sort of jury trial context if it's $20 or more? Look, I don't know, dude. I've never really thought about that before. But I'm telling you, I'll keep an open mind. Or if I have thought about it, then I can tell you. If it would be respectable to put in a concurrence, I think it should be respectable to talk about in a confirmation hearing. That has not been our norm, but I don't think that norm has led to very satisfying results. So that's my view. And that's different than like personal views, right? Like I'm not so sure a nominee should be required to like list, which parts of the catechism of the Catholic Church they do and don't agree with. That feels weird to me. This is a judicial post, and I don't think that kind of prying would be very useful. But that's my view, even though it was unsolicited.
Let's give a warm thanks to both our speakers.